as far as today's topic, the healthcare alphabet, as most of you know, we have a pretty busy elder care law practice. And yes, as lawyers, we focus on the legal documents and, of course, we focus on the strategies. But anybody that's worked with us knows that we are a bit different in that we also focus on the care. All right. It's the care of our loved ones that usually drives us to pursue the planning and the asset protection and the Medicaid benefits. It's really all about the care. So in that situation, the care world can actually be a little more complicated than the legal and the financial world. All right. And when they all come together, which is in elder care and long-term care, it's when everything comes together. It's where overwhelm can come in. It's where mistakes can be made. So again, the purpose of today is to share and spend some time trying to untangle the different healthcare documents that we use and the different terms that we run into, and you may run to as well as we're working with our families. All right. So let me get started on that. I'm going to do the screen share again. Here we go. Make sure I get the right screen up there. Okay, while that's loading. Okay, so one more time. This will be the last time, I promise. Just let me know you can see my screen, please. One of the first times I did this a couple months ago, I didn't do the screen share, so that's why I always ask this question. If one person could just let me know you can see my screen, the title slide. All right, great. Thank you. Let's get moving. Okay, great. So why is all of this important? I always like to start at the beginning. And the bottom line, these healthcare documents, these healthcare terms are so important is because of one word. And that word is incapacity. Okay. The reality is that if you're turning 65 this year, there is a 70% chance of needing some type of long-term care as you age. All right. That means you're going to need some type of help in the future. And what we want you to do is to set up some type of plan before any incapacity or decline occurs. It can be, we see this. There can be a coma, there can be a serious injury, there can be a terminal illness, there can be a dementia developing, or it could be as simple as anesthesia. All right. There needs to be a plan as to who can help and what your wishes are. All right. So that's what today is about on the healthcare side. The bottom line is that failing to have a plan in advance can certainly cause problems and lead to greater stress. And whenever there is stress involved and it's a crisis, then there'll be less options. It's going to cost more. The stress and the overwhelm is just going to compound upon yourself and upon those you love and your caregivers. So plan in advance, okay? I'm going to get that as a bumper sticker on my car. That's what we're trying to get you to do, all right? So what this is called is advanced care planning. And on the legal side, we use what's called advanced directives, okay? So what exactly is an advanced directive? Well, I'll start by saying that 2/3, nearly 64% of Americans do not have an advance directive, okay? So let me explain what that is. An advance directive is a document where you make a provision, where you lay out your healthcare decisions in the event you become unable to make those decisions in the future, okay? There are two main types of advance directives where you, in writing, lay out what you want to have happen, okay? The first one is called a living will, and the second one is called a healthcare proxy. In New York, we call it a healthcare proxy. Other states call it a healthcare power of attorney. Again, New York public health law, as it's laid out, calls it a healthcare proxy. To me, it's more direct as opposed to having two different types of powers of attorney. So we have a power of attorney for finances, and then we got the healthcare proxy for healthcare decisions. All right. We'll spend a few minutes talking about those documents, and then I'll get into some of the medical terms. All right. So first is the healthcare proxy. Okay. Or HCP, of course, to add to the alphabet there, but the healthcare proxy. That's the written document where you are allowed to appoint and encouraged and should appoint one person at a time to make healthcare decisions for you if you can't make the decision yourself. Okay? So, a couple points there. It's in writing, all right? New York actually has a statutory form healthcare proxy in, again, the public health law. And that form should be followed. And that form simply says and serves one purpose to say, if I can't make a decision for myself, then this person is the one to do it, period. Okay? Now, a couple caveats. It cannot be two people. All right. You cannot have co healthcare proxy agents. The law says you're allowed to have one at a time. You can have two in succession or even name three. So you can say my primary healthcare agent is, my wife. My secondary or contingent or successor healthcare agent is my son. And then my third is my daughter. You can do that order, but it's only allowed to be one at a time. Contrast that with the financial power of attorney, where you can have upwards of 2, 3 people and still keep it workable. Okay. So again, healthcare proxy only allowed one at a time. In addition, the healthcare proxy form, as you see it, and people will sometimes get it from a hospital, it's not entirely complete. It's missing a sentence that usually gets handwritten on the hospital form that says my agent knows my wishes about life-sustaining or rather artificial hydration and nutrition. My agent knows my wishes about artificial hydration and nutrition. That needs to be in the form. Otherwise, your healthcare proxy agent cannot make decisions about feeding tubes and etc. Okay. Again, you want it to be in writing. Now, the interesting part here is the healthcare proxy is not effective immediately. The healthcare proxy only comes into being if the principal that appointed you is no longer able to communicate or can't make decisions on their own. Okay. On occasion, we'll get a child call us and say, I'm my mother's healthcare agent and the doctor won't talk to me. Well, that's because your mom does still know what she's doing. All right. So the healthcare proxy, again, only kicks in when the principal who signed it can no longer act on their own behalf or make decisions. All right. Very important document. Should be kept short and simple. The Hipaa. Whenever we're talking about a healthcare proxy, we talk about Hipaa. Yes, another acronym. The Hipaa stands for Health Insurance Portability and Accountability Act. All right. We've been dealing with this since 1996. And we include Hipaa provisions in our healthcare proxy document. It's the only addition we make outside of the standard form. All right. In addition to, of course, the sentence about artificial hydration and nutrition. Okay. Now, Hipaa, that came to be, but the primary reason that Hipaa came about was all about privacy and actually protection of your personal health information. Okay. The law mandates that there's certain standards for the protection and confidential handling of, again, this PHI, the personal health information. All right. Quite honestly, it's why we're always signing new privacy releases and authorizations when we go to our doctor, whenever we're in their office. Again, very important. Attorneys go back and forth. It should be settled that a healthcare proxy agent can automatically see your personal health information. If they can't, then how are they supposed to help make decisions about your healthcare treatments? So, but to be sure and conservative, we always include Hipaa provisions again in our healthcare proxy. Now, moving on to the living will. That is another legal document that we put together and implement if it's appropriate for the client, the LW. Okay. Now, what is a living will? So, apart from or to distinguish it from a healthcare proxy, the living will is not created by statute in New York. I said the healthcare proxy is. So, Albany and the legislature actually signed a law saying this is what a healthcare proxy should look like. We don't have that in New York for a living will. A living will was created by a court. All right. It was a case. There's been a number of cases throughout the nation, but there was a case out of Westchester County a number of years ago where a judge said in regard to end-of-life treatments, the patient should have a quote-unquote living will type of document. So the living will is a statement as to how you'd like to be treated or what types of treatments you would like to have happen if you're at that end of life scenario. What it says is that if I'm in an irreversible or incurable condition, I do not want any medical treatments that merely prolong the dying process. Okay. So if you agree with that statement that you don't want medical treatments to prolong the dying process, then you should have a living will. If you want medical treatments to keep you alive, then you're not going to sign a living will. Okay. Think this through. Have talk to your loved ones, talk to your doctors if you need to, talk to your elder care attorney about this. But a living will is important guidelines that your healthcare agent can use as they make decisions to help you down the road. Okay. The living will also says that it lists those medical treatments. So it'll say, if I'm at that, basically at that point of no return, as I explain it to my clients, I try to explain things as easy as possible. And it really says, if I'm at that point of no return, if I've got one foot out the door, so to speak, I don't want feeding tubes. Okay. I don't want ventilators. I don't want respirators. I don't want antibiotics. I don't want dialysis. It then does say, I want maximum pain relief. Okay, period. My documents will say the wishes and then the treatments, and then it says, I want maximum pain relief. Some forms you'll see out there, perhaps your existing form or something you'll download from the internet, will say, I want maximum pain relief, even if it hastens my death. I don't include that last phrase. I usually bring it up to clients, but it's a phrase that I think that the family needs to handle on their own. So I ask for in the statement, the client will state that they want maximum pain relief for comfort, but the hastening of death is not something that I, as an attorney, am comfortable with. That's between the family and doctors and their God. So my document simply says yes to pain relief. Okay. A living will is not a DNR. That always comes up. We'll bring up the living will document and they'll go, oh, that's the living will. And that's fine. Forgive me, that's the DNR. And that is the right conversation. Okay. But they are separate. And I'll be talking about the DNR in a bit. The living will is a legal form that we can help implement, that the attorney can help put in place. All right. Now, I always like to make the point that the healthcare proxy and the living will, in my opinion, should be two separate documents. It is not one document. We will often see when clients come in with existing plans from other attorneys or something they put together themselves online, you'll have a healthcare proxy saying, I appoint my wife to make decisions for me. And by the way, I don't want any life sustaining measures. To me, that's not the best or most efficient way to handle this situation. The healthcare proxy was created by, again, the legislature. It's short and sweet. Doctors and nurses don't have a lot of time. Just state, this is the person that's here to help me and make decisions if I can't do it myself, period. The living will is entirely for a different circumstance, usually. Okay. It's for the end of life circumstance. So I don't like them combined because I don't want to muddy the waters. Okay. If you go to a hospital and give them a healthcare proxy with that living will language in there, then that's going to go into your chart, the living will. All right. And you're that much closer to end of life issues. You're that much closer to decisions being made, perhaps that you didn't want to be made yet. All right. So what we tell clients is file the healthcare proxy with the hospital, get it in the chart, leave the living will at home. All right. I like to have the client and the family with that much, little bit more, that much more control so that they get to bring up the conversation about passing and end of life treatments when they believe mom or dad or wife or husband didn't want to be in that condition anymore. Okay. Again, I like two separate documents, and I believe it's not scientifically proven, but I believe it gives the family a little bit more control. Okay. Then we get to the DNR, okay? So healthcare proxy, living will, attorneys, those that are experienced in elder law and elder care are the ones, and estate planning, those are the ones that should be putting these documents together, all right? Go to an attorney that knows this type of work, all right? That way it becomes a part of a plan that will help you and the family as you age. Getting into the medical side of the forms, okay, and the medical side of these healthcare documents, the DNR first. So a DNR, as most people know, is a do not resuscitate order. All right. It can be considered an advance directive. All right. You can have it in place in advance. The bottom line is that if you're in a hospital, that staff will try to help any patient whose heart has stopped or who has stopped breathing. All right. They help with what's called CPR, cardiopulmonary resuscitation. Okay. Cardio heart, pulmonary lungs, resuscitation. So DNR is all about CPR. Okay. The DNR is a request to not have CPR if your heart stops or if you stop breathing. Okay. That's how it works. And that's a nice, easy way to remember it. The DNR is about CPR. It's not about other treatments or conditions. Okay. Um, it's a discussion for you and your doctor. All right. And if you agree to a DNR, or if your healthcare agent, if you're unable to make the decision, if your healthcare agent agrees to a DNR, it goes into your medical chart and it lasts for that period of time. It's typically done in a facility and lasts during that facility stay. There is also what's called a community DNR or an out of hospital DNR, and that can be ordered for you to take with you when you're at home. And if you have to call EMS or 911, then that's what you would use to say, I don't want that treatment. So DNR, very important, and hopefully just to shed some light on how that works and what it actually means. Next is the DNI. So DNI stands for do not intubate. Usually the discussion about DNI is at the same time as the DNR. I've even had clients say they've never heard of a DNI when they were getting and implementing a DNR for their loved one. Not sure what happened there. DNR and DNI should be the same conversation, okay? Separate decisions, but usually the same conversation. They're two separate treatments, all right? So do not intubate. So intubation is where the doctor will insert a flexible plastic tube either through the nose or through the mouth down the trachea, all right, the windpipe, to help with the breathing, okay? And then that tube is connected to a ventilator. Unfortunately, we've heard a lot about ventilators over the last couple of months, but it's a way to keep the lungs breathing. It's a way to get oxygen into the lungs. I'm told that a DNR and DNI orders should be separate because you can have trouble breathing before your heartbeat or your breathing stops. Okay. So if breathing problems continue and aren't treated, your heart and lungs may go into full arrest, and that intubation, all right, may actually reduce the chances of cardiac or respiratory arrest. So, in other words, you can have a DNI that says, don't intubate me, but there may be some jeopardy in that because that intubation may prevent actual cardiac or pulmonary arrest. Okay, again, these are all doctor questions and doctor conversations. I'm just trying to share the concept. Statistics can help. Okay. Unfortunately, I have found out through my research and talking to doctors that there's a romanticized, if you will, type of feeling about CPR, that it works all the time and that it's a simple procedure. It's not. It's generally not for those that are very frail. It's a hard procedure. It's one that with a lot of physical force that can hurt people. So those types of discussions and decisions need to get made with your doctor. But if there is actually a cardiac arrest within a hospital and CPR, only about 25% of those patients survive that. Okay, so less than a quarter of the people with CPR survive. However, those that require intubation for breathing, over 60% of those people survive. All right. So know what you're talking about, do your own research, and again, talk to the doctors as to whether a DNR and a DNI is appropriate for you. Okay. It's the best way to handle it. Have those conversations in advance with the doctors first, and then with your family and your healthcare agent. Okay. I cannot stress enough how important it is that your healthcare proxy agent and your family, if appropriate, know your wishes about living will treatments, DNRs, and DNIs. Okay. All right. Moving on. And of course, if we're talking about DNRs and DNIs, we have to mention what a full code is. All right. It's the opposite of what we've been talking about. A full code means that you do not want a DNR and a DNI. It means that you do want electrical shock, the paddles, and it means you do want the chest compressions, and that you do want intubation if necessary for the breathing. Okay. So a full code means they're going to do everything they can to get you back and to keep you going. Okay. The opposite of a DNR and a DNI. All right. Okay. So we've covered the legal documents for advanced care planning, the living will and the healthcare proxy. We've covered some of the common medical, DNR, DNI, full code. Then you have the MOLST. Okay. MOLST is an acronym for Medical Orders for Life-Sustaining Treatment. Again, Medical Orders for Life-Sustaining Treatment, MOLST. And you might be saying to yourself, why in the world would he be using a bright pink font like that? Well, it's because the form itself is a bright pink. The theory behind the MOLST form is that it is meant to be seen and found quickly. All right. So therefore, bright fluorescent colors. All right. The MOLST document itself is an initiative throughout New York State and other parts of the country. It started out in the Northwest first. It's an initiative to facilitate end-of-life medical decision making. All right. It's all about end-of-life medical decision making. There are other programs in other states that start with the letter P. So it's called a POLST instead of a MOLST. And you'll actually see the form on the screen. If you can read it, it actually says POLST. That stands for Physician Orders for Life-Sustaining Treatment versus New York's version, Medical Orders. Okay, it's meant for those that have an advanced illness. The form states it's if the prognosis is 1 to 2 years of survival, they are saying, New York doctors, physicians, healthcare teams are saying a MOLST should be discussed if you're nearing the end of life. They also say that if you're in a long-term care facility, such as a nursing home, you should have the discussions about a MOLST with your medical team. Lastly, if you're somebody that just wants to lay out and document your life-sustaining treatments, again, they're saying, the government is saying this is the best form to do that. It's not a legal form, all right? It's a form that you can find online or talk to your doctors or your hospital and read it through. It's meant to be completed with the doctor or with the nurse practitioner or with the physician assistant, the doctor, the NP, or the PA. It's not something you're supposed to do on your own, okay? There are protocols that are meant to be followed. First off, does the person fall in that category of whether they should have a MOLST form or not? Number two, and there's others, but number two, is there the proper capacity, mental capacity to have these discussions and to make these decisions? All right. It's supposed to help put in writing the patient's wishes about resuscitation. All right, here we go again, CPR. And it also is to put in writing the decisions about DNI and intubation, which is the breathing. Okay, now it can also document wishes as far as hospitalizations and transfers to other facilities. It can detail your wishes about feeding tubes, about antibiotics, about dialysis. It's meant to be a comprehensive form for end-of-life treatments. Okay, it's different than the DNR, because you might be saying, why would I need that if I have a DNR or a DNI? This is different from those forms not only from the comprehensive perspective, but that it is an active medical order, all right? It's something you can take with you from the hospital to the rehabilitation facility, to the nursing home, discharged back to the assisted living or back to your home. That's why it's bright pink, so you can find it easily wherever you're going. So again, the difference is this is an active medical order, okay? Very honestly, when these first came out, I did not like them. To me, and I still believe this to be true, that a well-informed and responsible and assertive healthcare proxy agent is the best way to go. To have an active, living, breathing person able to talk to doctors, probe and ask questions about this and about that treatment and that prognosis, and if this happens, then what? That is the best way, in my opinion, to handle end-of-life decision making. In lieu of that, then you have MOLST, then you have the living will, then you have the DNR and the DNI. Okay, so it's the person to make the decisions, and it's not just any person. It's a person that knows your wishes and has the ability to advocate for you. That to me is the best way to go. And then you have the papers, MOLST, DNR, DNI, living will. Okay, they can all work together. All right. So my appreciation for the MOLST form has grown through the years, because when they work together with the healthcare agent to make the decisions, then to me that is the best way to address these end of life decisions altogether. Okay, that's the MOLST situation. Now, as I said in the beginning, all of these topics and documents need to be discussed with your attorney and or your doctor, okay? But most importantly, they have to be a part of a plan, okay? Willy-nilly doesn't work. Cobbling it all together doesn't work that well. Waiting to the last minute and allowing a crisis to occur does not work at all. All right. Again, increased cost, increased stress, increased delays, less options. Crises need to be avoided. The courts need to be avoided. And I bring up the courts here on purpose because if capacity is lost and there's nobody to help with financial decision making and your wishes are unknown, there may be a struggle as to what mom would have wanted. Okay. And then you may be forced into another court proceeding called a guardianship. So documenting your wishes in advance as a part of a plan is the best thing you can do, and it's the best recommendation I can make. Okay. And yes, that's where we come in. All right. Again, I do these webinars to help educate and to help you know that we're here to help with everything I'm talking about. Okay. And a little quote for you. A man or woman, for that matter, who does not plan long ahead will find trouble at his door. Okay. And I'm going to add quickly. All right. Plan ahead. That's the bottom line. Now, our plans, where we come in to help, is through estate planning, through what we call elder care protection planning, and through our signature service, what's called life care planning. So an estate plan is really for the younger folks, all right? No health issues. You're talking about wills and durable modified, which are comprehensive powers of attorney for finances, the healthcare proxy, and the living will. In addition, in an estate plan, we can talk about something called a revocable trust, which has one purpose, and that's to keep the family out of the courts, out of the probate proceeding for the courts and the surrogates court, okay? So estate planning, younger, healthier folks, and avoiding probate. That's what that's about. The Elder Care Protection Plan, that's evolved over time, and I'm very happy with the services that are out there right now and included. The Elder Care Protection Plan is for those mid-60s and older, all right? We've done them for folks in their 60s, and we've done Elder Care Protection Plans for folks in their 90s. They made it that far without any issues. But an Elder Care Protection Plan has two purposes. It's to protect your assets, and it is to start to prepare for care, all right? An elder care protection plan will include an estate plan. So you'll have your wills and your powers of attorney that are modified, your healthcare documents, but you'll have the irrevocable trust That's the asset protection tool to shelter your assets for future long-term care needs. If you have questions about that, I'll talk about it anytime, or you can go to the website, like I said earlier, and look at that webinar all about the irrevocable trust, okay? The elder care protection plan, again, helping the family prepare for care down the road. And then finally, our services when it comes to planning is the life care plan. We're very unique, like I said in the beginning. I have the attorneys, the experienced, caring attorneys, but I also have my advocates on staff, a geriatric social worker, a board certified patient advocate. So the attorneys and the advocates work together, all right, with the goals of protecting the most assets and income, getting Medicaid to pay for the care, and getting the client, getting you the best care possible. That's what the life care plan is all about. And all of these plans will include the advanced directives for that advanced care planning. Okay. So that's what we do. This is how you can contact us. I'll check, of course, if we have any questions from today's material in a moment. But if you have other questions, feel free to email. If you want to request a topic, shoot me an email. Brian, BRIAN, at Tully, TULLY, elderlaw.com. Or for those folks on the phone, 631 424 2800. All right. Again, thank you for participating and being on this webinar. Look out for next week's webinar. Okay. Let me now get rid of this and see what kind of questions we have here. All right. Please, if you have any questions, put them in the attendee chat. All right. So, first question. Mom has a healthcare proxy that I think names two people. All right. We've seen that. The reality is, and the problem is that is not that's not the proper way to do it. The healthcare proxy is allowed to have one document, one agent appointed at a time. Perhaps it was the doctor's lobby up in Albany that won that issue. Let me stop sharing the screen here for a second. Maybe it was the doctor's lobby, as I was saying, and they insisted in saying, we only want to talk to one person. We need one decision maker. So healthcare proxy, again, one at a time, it should be updated. In that vein, if you have a healthcare proxy that also includes all the living will language, consider what I shared earlier and revamping them so it's two separate documents. We've been through some rough times over the last couple of months. Just yesterday, a friend told me her mother was put on a vent. These things happen, okay? We've been through rough times with this pandemic. These discussions, I can only hope and pray these discussions happened before all of these bad things were occurring. Sometimes there's no question. You need a vent, period. They're not talking, they're just doing. I get that. But having discussions about end of life healthcare, having discussions about end of life choices, very crucial and very important. All right. So I encourage you. No other questions for today, and that's fine. Please, again, shoot me an email or give a call, and we'll be happy to help. And I will see you next week. All right. Again, thank you. Bye-bye. Thank you. You're welcome. Bye-bye.